What is mootness? Mootness is the justiciability doctrine that asks whether a dispute remains a live case or controversy, such that a court can still grant effectual relief, or whether intervening events have made the case so academic that judicial decision would be merely advisory. Mootness is about timing at the back end of a lawsuit. Standing screens cases at filing. Ripeness checks whether a dispute is developed enough to decide. Mootness asks whether the dispute has gone stale before judgment. If, at any point, it becomes impossible for a court to provide meaningful relief to the plaintiff, the case must be dismissed as moot. This flows from Article 3's ban on advisory opinions. Federal courts resolve concrete disputes, not hypotheticals. A bit of history. The Supreme Court's early statements, e.g., Mills v. Green in the 1890s, made clear that when events extinguish the controversy, say an election passes or a challenged order expires, the judicial power ends. Over the 20th century, the court refined exceptions to prevent strategic manipulation or the loss of review for inherently short-lived disputes. Two landmarks, United States v. Munsingware, 1950, which introduced vacatur of lower court judgments when a case becomes moot on appeal through no fault of the losing party, and Friends of the Earth v. Laidlaw, 2000, which placed a heavy burden on defendants who try to moot a case by voluntarily stopping the challenged conduct. Here are the core rules and main exceptions. 1. Voluntary cessation. A defendant cannot automatically moot a case by stopping the challenged behavior mid-suit and promising not to resume. The case remains live unless it is absolutely clear the wrongful conduct cannot reasonably be expected to recur. The burden is the defendant's. Government policy changes may weigh in favor of mootness if the change is durable, e.g., repeal by statute. But mere internal memos or temporary suspensions often aren't enough. 2. Capable of repetition, yet evading review. Some controversies are too short-lived to be fully litigated, but likely to recur to the same plaintiff. Classic examples include pregnancy-related disputes and election law challenges. The test has two parts. A. The challenged action's duration is inherently too brief for complete litigation. And B. There is a reasonable expectation the same plaintiff will be subject to it again, sometimes relaxed in election cases. 3. Collateral consequences. Even if the primary sanction has ended, concrete legal disabilities that persist keep the case alive. A criminal conviction carries ongoing consequences: loss of voting rights, registration requirements, enhanced sentencing exposure. So a challenge to the conviction is not moot merely because the sentence is served. Similar logic applies to immigration orders with lasting bars or civil penalties that trigger continuing regulatory burdens. 4th, class actions and relation back. If a named plaintiff's individual claim becomes moot before class certification, courts may allow certification to relate back to the filing date for claims that are inherently transitory, ensuring the class claim remains live. Also, an unaccepted offer of complete relief does not moot a case. Plaintiffs cannot be picked off by tender offers. 5. Nominal damages. A demand for even $1 can preserve a live controversy for completed past injuries. A court can still award effectual relief by recognizing the violation and issuing nominal damages. What happens when a case moots on appeal? Under the Munsingware principle, the appellate court often vacates the lower court judgment and remands with instructions to dismiss, preventing an unreviewable decision from having preclusive effect. But if the party seeking vacatur caused the mootness, for example by settlement, vacatur is typically denied in equity. Concrete examples help. If a student challenges a school's graduation policy but graduates before judgment, the injunctive claim is usually moot, unless the dispute is capable of repetition yet evading review, or a certified class remains. If a city repeals a contested ordinance after suit is filed, the injunctive claim may be moot, but not if there's a realistic chance of reenactment. Voluntary cessation and damages claims keep the case alive regardless. A 30-day restraining order that expires mid-case may be moot unless it's the sort of short-duration order likely to hit the same plaintiff again. A habeas petition challenging a conviction is not moot upon release if collateral consequences persist. Bottom line, mootness prevents courts from issuing advisory opinions when relief is no longer possible. but carefully crafted exceptions ensure defendants can't game the system, and that fleeting yet important controversies still get their day in court. Above, you'll find more videos to keep learning law. Remember to leave us a like and subscribe.